All right. Actually, I think I will go ahead and say this, that we have spent a good chunk of time over the last day or two talking mostly about what's going to happen. And it would probably be a good idea if we are going to arrogate to ourselves a certain amount of forecasting, of predicting what will happen in the future, to see whether, in fact, we really even have the capacity to predict what happened in the past. And what we have here are four people who are expert and practiced in that particular kind of forecasting. And what we're going to do is just move down the table in roughly 15-minute increments and give each of these folks a chance to speak about technology IP and the past in a particular context, and then open it up to questions. And so, without wasting any more of your time, Bruce Boyden.
Thanks, Ross, and I want to thank the organizers of CPIP for putting on this wonderful conference and inviting me here to speak today. So the theme of the panel is what lessons we can learn from the history of IP and technological shifts, and I want to focus on two periods, the 1970s and the 1930s. So I guess neither of those quite gets up to the 90s, but I'll get there. First, the 1970s. So copyright law experienced a fundamental transformation during that period, separate and apart from the Copyright Act of 1976, namely the beginning of the computer revolution. Obviously, a lot's been said about the effect of computers on copyrighted works, but I think less attention has been paid to the way in which computer technology, and in particular networked computers, have undermined the distinction between public or commercial uses on the one hand and private or personal uses on the other, on which copyright is built. Until the 1970s, mass production of cultural goods worked much like mass production of any other good, creating a chain from producer to distributor to consumer where it stopped. Copyright's rules have always been phrased as universal obligations, however, that everyone in that chain is subject to, but as a matter of practice, that's not how it operated. Prior to the 1970s, rival creators of works sometimes sued each other, and producers and distributors sometimes sued each other, but there was no feasible way for ordinary individuals who were not professional artists or creators to impinge upon the rights of a copyright owner. As a result, consumers could essentially do whatever they wanted with the works they purchased or consumed within the confines of their normal personal sphere of activities. And copyright, as it has developed over most of its history, is essentially an industry or professional regulation on fellow producers and distributors of works. The Copyright Act of 1976 is in several ways built on these assumptions. Not only is there a large number of provisions aimed only at particular industries, cable television, broadcasters, libraries, advertisers, and so on, but also many of the core provisions of the Copyright Act of 1976 are built on this assumption. For example, in the fair, what's going on? That's not where I wanted to go. In the fair use, in the fair use section, in section 107 of the Copyright Act, the first factor, the nature and character of the use, focuses explicitly on a contrast between two types of public uses: commercial uses that are presumptively unfair, and nonprofit educational uses that are presumptively fair. That's the text of what was written in section 107. The fourth factor, the harm to the value of or potential market for the work, focuses most naturally on activities in the public realm that will affect or displace sales of the plaintiff's work, and less easily on non-commercial or private activities. What Congress said it was doing, actually, in Section 107 was merely adopting what courts had previously said were fair uses, but that's not actually correct. The fair use factors are, in fact, derived from an old test for substantial similarity. That is, a test for answering the question of when has a rival producer of works taken too much to be allowed to go forward. In other words, fair use, as it's been defined in the text of the Copyright Act, comes from a test for commercial regulation and it's ill-suited for other sorts of disputes. So courts have essentially improvised as a result since the 76 Act was passed, most famously in essentially replacing the end of the first factor, the reference to commercial or nonprofit educational uses, with the transformativeness test that judges feel gets at the purposes of fair use, or the exclusions that are supposed to be built into fair use, better, which is subject to some debate. So next, consider the definition of public performance. So public performance is defined as either occurring in a public place or by transmission to the public, getting rid of the 1909 Act's old requirement that the performance be for profit. As a result, both individuals and professionals can theoretically engage in such performances, the only limiting factor in the 1970s being the cost of doing so, which effectively kept individuals from engaging in something that would be a public performance that would be worth suing over. It was the copying technologies that first became widely available to consumers in the 1970s that undermined these assumptions. So, you had the widespread adoption of the photocopier, the audio tape recorder, and the video cassette recorder. So none of them computers just yet, but these are technologies that brought copying ability into the hands of your average individual. And the copies made with these devices could be used to displace marketplace sales in a serious way, even if made in the personal sphere. This put the boundary between the personal and commercial uses to the test. And the response has generally been to try to shore up that boundary between personal and commercial. So Justice Stevens, in the Sony Betamax case, originally wanted to do exactly that. This is his heavily marked up first draft opinion, in which he, as he originally wrote his what was originally a dissenting opinion, he would have declared that all acts of personal copying were beyond the scope of copyright and therefore non-infringing. He only changed this opinion at the last minute when it became apparent that he could turn his dissent into a majority opinion by casting it in terms of secondary liability for Sony, resulting in the Betamax test that we are familiar with today, which is extremely forgiving of device makers and service operators, no matter what the devices or services are actually being used for by the individuals using them. And then later, in the mid-1990s, when it became apparent that not only could copies be made by individuals, but they could be distributed worldwide using the internet, the solution was, again, to try to shore up that boundary between personal and commercial by limiting the escape of content from the personal sphere in three ways. Through takedown notices in Section 512 aimed at particular uploaders, or through anti-circumvention rules in Section 1201, or at times through lawsuits aimed at particular infringers trying to get individuals to comply with copyright. And the problem with these efforts is that copyright is not well designed as a regulator of individual behavior. The rules are either too complex or too vague for someone not steeped in it to follow effectively. And at least some of the public frustration with copyright law has come from the sense that it is now intruding in personal spaces, governing what can be done with media that has entered the home in a way it did not before. And it's a result of both the expansion of both what public uses or what media has become available, and the expansion of what individuals are capable of doing with it once they get their hands on it. And the collapse of those boundaries is only going to continue. So it's not just the computers are connected. It's not just computers that are connected to the internet, creating or copying content on an individual project basis, but soon all of our devices will be interconnected all of the time. And those devices are creating and storing content remotely, not just inside the home, and increasingly sharing it widely with others. The result is that tendrils of the personal and the public are increasingly interweaving with each other until it'll be difficult to say where one stops and the other starts. And it's not just copyright. So this collapse or merging of the physical personal sphere is affecting a number of other legal or social areas, our notions of privacy, computer security law, and many other fields as well. And it's probably unstoppable. So I think one lesson we should take away is that we should remember how copyright worked in the 1970s in plotting the way forward. I think copyright is best structured as a regulation of industries and professionals, meaning that the primary obligations associated with our copyright system are best placed on those industries and professionals. That includes, obviously, copyright owners, who will continue to have the obligation to enforce their copyrights. But it also includes internet distribution intermediaries who stand at a natural choke point in the distribution of content and have the resources to understand and comply with the law much better than your ordinary media-consuming individual. But of course, finding a workable solution that identifies obligations that are feasible and rules out obligations that go too far will not necessarily be easy, and it hasn't proven to be. My final lesson addresses that point and comes not from the 1970s, 80s, or 90s. That wasn't old enough for me. It comes from the 1920s and 30s. And that is the adoption of the public performance right for music. The music public performance right was added in the 1909 Act, and unlike the dramatic public performance right that was added in 1856, it had the effect of subjecting a whole new category of businesses to copyright compliance. So all of a sudden, for the first time, bars, restaurants, dance halls, nightclubs, hotels, and other businesses had to worry about whether the musical performances in their venues were licensed. The result was what can only be described as massive resistance, as such businesses continually refused to pay public performance licenses, raising various defenses that repeatedly got shot down by courts, such as that purchasing a copy of the sheet music implied permission to publicly perform it, or that where no admission was charged specifically for the music, the performance was not for profit. Even after the Supreme Court shot down those defenses and upheld the public performance right in 1917 in Herbert versus Shanley, small businesses continued to refuse to pay. And it did not improve even after the formation of ASCAP in 1914 that allowed these licenses to be paid on a collective basis. In fact, in the 1930s, it was still so controversial that a number of state legislatures, at the behest of their constituents, passed laws essentially outlawing ASCAP's activities in their states. So I've come across at least 5 different laws that were litigated, most of them all the way up to the Supreme Court. And ostensibly, those laws, according to the people who passed them, were driven by concern over ASCAP's monopoly powers, the only public performance or music public performance collective rights organization. But the statutes made no mention at all of any competitive effect. Instead, they tended to bar any attempt by more than one composer to jointly collect public performance licenses in a state and subjected any composer or any group violating the law to be deemed to have licensed everyone in the state to perform those compositions for free forevermore. That continued for almost a decade until finally the Supreme Court, in several different cases, struck down those laws, and the consent decrees with ASCAP and BMI in 1941 addressed the antitrust concerns. So what's the lesson from all this? There's 2, actually. The first is that a shift in copyright obligations to a new set of entities, like what we are seeing with ISPs now, is likely to cause significant turmoil and resistance that may persist for years or possibly decades until it's finally settled. But a second lesson is more hopeful, that eventually it is, or at least the history points to the fact that it is possible to settle these disputes. A workable solution that's not overly burdensome to any one group, copyright owners, distributors, or the public, can still be found even after such turmoil, even if, or perhaps especially if, it is not completely satisfactory to any one party. Eventually, that sort of compliance can become just routine, as site performance licenses are now. And that's where I hope we are in 10 years. So at the hazard of predicting a hope, I guess, if not a forecast, that's what I hope happens for ISPs.
Thank you, Bruce.
Thank you.
But a little hope.
Here is your remote clicker.
Oh, thank you very much.
Joe Gabriel.
Okay, hi everybody. Thank you for the organizers for the invitation to come talk to you. I'm really excited to be here. So I'm a historian of medicine, primarily. I work on the history of the pharmaceutical industry and its relationship to medical and scientific communities. my work has primarily been in the 19th and early 20th centuries. So today I'm going to be talking just a little bit about academic life scientists, right? Physicians, pharmacologists, pharmacists, biologists, botanists, but mostly physicians and pharmacologists. And I'm going to be talking about the interwar period between World War I and World War II, right? And a very important moment when academic life scientists first began to patent their discoveries, okay? And I'm going to tell you a story about how academic life scientists went from being anti-patent, okay, so being against patenting, to being very open to patenting and kind of enthusiastically embracing it over the course of this period. I think, Ross asked us, if we can predict the future, right? I'm sorry, that we've been predicting the future, but can we predict the past, right? And I actually would say, no, we can't, right? So historians aren't actually in the business of telling what happened. We're actually in the business of telling stories, right? And we use evidence to make stories about the past. You may not agree with my story, right? But I'm willing to argue for it. In any case, some background. So this is my first book that came out a few years ago. And this is an overview of 19th century debates about patent and trademark law, and also trade secret law to a lesser extent in the 19th century drug industries and drug development communities, right? And one of the things I found is that among physicians, pharmacists, and reputable drug manufacturers in the 19th century, right, is that drug patenting was considered an unethical and unscientific form of monopoly, right? So monopoly rights were juxtaposed to ethical scientific practice. Medical science was understood to be based on the open circulation of information among reputable peers, okay? Medical science was assumed to be benevolent, or at least that's what they said. It was benevolent. It was for the common good. It was for the public good. And so it was juxtaposed to self-interest, okay? Patenting was understood as a form of self-interest and the monopolization of medical knowledge that therefore harmed the public, okay? And this is really the dominant framework for understanding drug patenting during the 19th century. So, for example, here's the Code of Ethics from the American Medical Association in 1847 that says it is derogatory to professional character for a physician to hold a patent for any surgical instrument or medicine, or to dispense a secret nostrum, whether it be the composition or exclusive property of himself or others, right? It was unethical and unscientific for a physician to patent a drug, but even to prescribe it, okay? Even to prescribe it, okay? This translated into reputable drug manufacturers refraining from monopolizing their goods, okay? So through the 19th century in the United States, American ethical drug manufacturers did not patent their products. They considered it unscientific and unethical. They also knew that if they patented their goods, they would run afoul of the medical community and they would be denounced as quacks, right, and therefore lose their markets. So one result of this, right, was that all manufacturers in the ethical wing of the industry, there's also like this other wing called the patent medicine wing, which I'm not going to talk about, but ethical manufacturers, they all produced basically the same goods, right? And they competed on the domain of quality of product, right? Their advertising to a certain extent, but they all produced basically the same good, right? And they didn't really innovate in a commercially viable manner. Okay, so innovation was contained within scientific practice. So, the drug manufacturers might send a representative out to a distant part of the country and discover a new plant, right? But they would then share the information about the plant, and all the drug manufacturers would basically introduce it at around the same time, okay? So innovation, right? So they weren't really able to innovate in a commercially viable manner. Okay, so now by the early 20th century, though, this whole formulation had been reconceptualized and patents had been reconceptualized as both scientifically and ethically legitimate, okay? In my book, I wrote a lot about a man named Francis Stewart, who was a pharmacist and a physician. He worked very closely with Parke Davis. And Stewart and a series of other reformers introduced a number of arguments about patenting, drug patenting, that we take as commonsensical today, right? So for example, the idea that patents allow drug companies to invest in scientific development in order to recoup their investments, right? He came up with that idea, right? He was one of the people who came up with that idea, right? And doing that, one of the things that resulted in was that commercial manufacturers, it became ethically and scientifically legitimate for them to develop new products and monopolize the product, okay? So for example, right, he made this argument. Is it ethical for medical men to patent medical inventions? This is from the 1890s. It was a real question, right? It was a real question. It wasn't clear. He argued it was, because if you patent it, then you can invest in it, develop new products, so on, right? So Parke Davis, right, was adrenaline, which was patented in 1904, I think, 1903 or 1904, right, was the first major domestically produced pharmaceutical that was patented, okay? There's a whole story about German drug patenting also at this time. All right, so despite this, right, so despite Stewart and Parke Davis's and other reformers' efforts, right, a very strong current of skepticism towards patenting remained among physicians and life scientists, okay? So you can kind of see this change from it going from completely unscientific and unethical to being reconceptualized as scientific and ethical, and at the same time, a strain of critique and concern continuing into the 20th century, okay? And so that's where academic life scientists were in 1917, 1918, at the end of World War I, right? They operated in a moral economy, right? A sense of how they behaved, their ethical sensibilities of themselves and their colleagues, right? They operated in a moral economy that prioritized cooperation, sharing of information, truth-telling, disinterestedness, right? And similar kinds of norms, okay? And the disinterestedness is an important part of it, right? You couldn't be a scientist and act too self-interested, right? Because if you're too self-interested as a scientist, then your own sort of interests would impede on your scientific practice and it would undermine your reputation, right? So scientists at this time were opposed to drug patenting to the extent that they upheld the traditional and conservative norms of the medical pharmacy and related communities. Okay, this was the conservative position, right, at the time. Reputation, right? I think anyone who is an academic will recognize this, right? But reputation was of central importance to the self-understanding of academic life scientists, right? Their whole careers, their whole lives were built on their reputation, right, with their peers, right? Of course, reputation gets developed through credit, right? Credit for work, including discovery, right? But it's not only reputation about your work, it's reputation about, your attitudes, how you behave, right? Are you impartial towards your results or not, right? What kind of attitude do you take to your scientific practice? Do you do good scientific work or not, right? But reputation was also intertwined with how you behave outside the laboratory, right? Do you go to the right dinners, right? Do you socialize with the right people, right? Do your colleagues invite you over for dinner, right? That kind of reputational work was also incredibly important to the professional identities of academic life scientists, right? And then lastly, there was a vague but very real dedication to the public good. Okay. So starting in about 1917, there were a series of very influential, oh my gosh, I just got started. That's amazing. All right, well, I won't get very far. So there were a series of there were a series of very influential patents, right, starting in 1917, right? And the most common one that we know about is insulin in the 1921 patent, right? And these patents introduced patenting as a viable means. So this patenting took place along kind of three lines, right? One of them was patenting in the public interest. Patenting was assumed to be a way to protect the public from unscrupulous manufacturers, right? At the same time, licensing arrangements were designed to protect researchers' reputations, okay? So Simon Flexner of the Rockefeller Institute for Medical Research patented a drug called triparsamide, and he did it in order to protect the public, right? The patent was a way to protect the public, right? So as a result of these kind of ideas, patenting in the academic scientific community became reputable, okay? It became ethically legitimate and socially legitimate to do that, right? As that happened, patenting became a way for people to advance their own reputations, okay? So you have a reputation based on impartiality, dedication to scientific norms. On the other hand, you have patenting as a way of enhancing your own reputation, right? Through royalties, right? Getting funding relationships with companies and so on, but also through relationships, publication and credit relationships and so on, okay? The key point, though, for me, is that this introduced something of a contradiction, okay? So there's a contradiction between the kind of older style scientific norms, right, and the new norms, right, in which interest, personal interest, that could be linked to the development of patentable goods enhanced your reputation, okay? So Harry Steenbach invented the irradiation process, which allowed the production of vitamin D in food and pharmaceuticals. It was an incredibly important innovation in 1923, he patented it, right? It led to the elimination of rickets, right, as a public health concern. So it was a very important public health innovation. His patent made a huge amount of money for the University of Wisconsin, right? He personally made a huge amount of money from royalties from his patent, right? But he understood himself as distinct from commercial imperatives, okay? So he said, I have always made it a particular point to keep myself in the background in these commercial developments because it would hardly be seemly for me to enter the commercial field with its propaganda and still try to maintain the respect and confidence of not only myself, but also others who are inclined to evaluate accomplishments from the pure scientific standpoint. Okay, thank you. Right? So there's a contradiction for him here, right? Between his scientific practice, his scientific innovation, right? And his reputation with his peers, right? And he's worried about maintaining his reputation. Okay. I'll just make my last, it's not really my last point, unfortunately. One of the things this did, right? One of the things this did was it meant that academic scientists started to behave in ways that contradicted the formally articulated norms of their moral community, okay? Because there's this contradiction that developed between the norms of the scientific community and the norms of a commercially oriented scientific practice, right, that got linked to patenting, right? And I think I'm out of time, so I'll just leave you with this kind of comment, right, by Arthur Lovenhart. He was the chair of pharmacology at the University of Wisconsin. His unit was responding to the development of triparsamide, which at that point had become was just on the brink of becoming the primary treatment for African sleeping sickness on the African continent, right? So there was a huge potential market for triparsamide. And his unit was trying to develop a competitor to triparsamide. And they found two substances, right, that they thought might be good competitors and that they patented, all right? Now, according to kind of the norms of the scientific community, right, what he would have done was shared his research with his colleagues, talked with his colleagues about his work, right, and the work of his unit, right? But he didn't do that, right? What he did was he told the guy he was working with, to soft pedal the work on 73 and 74, right? Don't tell people about this, okay? Because this might be a big thing, right? This might be a really good thing for us, okay? The last kind of point I'll make, Arthur Tatum, also at the University of Wisconsin, was his successor, right? And he was also involved in a series of arsenical drug developments, right? And he developed a drug called Mafarsin, right? And this kind of tension, right? This kind of tension to behave in ways that advanced your ability to patent or commercially introduce a new product, but that contradicted the scientific norms, right? It also played out in his clinical research for Marfarsin, right? So they tested a variety of arsenicals on patients in the hopes of finding a patentable product, right? And you can see kind of at the end, right, that he tested one arsenical substance on a patient that was kind of way in excess of what was needed, right, for a scientific reason. And the idea was that he was trying to find, right, he was trying to find something that Park Davis would be able to commercially introduce, okay? But he did so at the expense of his patients. Okay, I guess I'm out of time.
And that's actually a good point to pause on, the expense of the patient's point.
Okay, I'll stop.
And
All right, but let me just.
we'll have more time.
Yeah. Let me just say, it's not all bad. It's not all bad.
Thanks, Joe. Thank you. Justin Hughes.
All right, thanks everyone. First of all, I want to thank Adam and Christina and Devlin and Kevin and the whole George Mason crew. And since it's the end of the day, I think we should have a round of applause for them. So thank you for organizing such a great conference. First, mandatory disclosure, which many of you have heard me say before, and that is that I absolutely hate PowerPoint. And I came to DC, I think PowerPoint makes us stupid, and I came to DC yesterday with no slides, and yet in the face of customs and norms, I was unable to get myself in front of you, well, deckless. So I sat there putting together some slides very quickly. So a mantra of the blogosphere, of course, is that new technologies are challenging copyright. And as a descriptive statement, that is true. But as a claim about how the world has changed, that is not true. And copyright has always been responsive to new technological challenges. And indeed, those of you who teach copyright may start with the idea that copyright at its inception was a response to a technological challenge, the challenge of the printing press, and in particular, the diffusion of that technology, the printing press, to places outside London. So taken literally, the panel's charge here was to draw lessons from how IP has responded to those technological challenges. And I will only fudge it a little bit time-wise, 1990s and before. But for myself, I tend to think about this as a policymaker. So with kind of a policymaker hat on, but also a professorial hat on, the first thing you do when you start thinking about something like this is to try to come up with a taxonomy. So what's my taxonomy? Well, first of all, there are broad, complete IP policy responses to new technological developments, and they usually seem to work. There are policy tweaks to respond to technological developments, and this is not timed very well. There are misunderstandings of how technology will develop and how difficult it is to correct those misunderstandings once there are entrenched players. And kind of most interesting, they're the technological developments that we ignore for as long as possible. And as I've thought about these, I've been trying to think about how and when does this happen? How can we use them as case studies like in business school or public policy school? And of course, and there isn't a slide here, but you know, you're a law professor, you always, even if you spend a lot of time in government, you fall back, can I apply public choice theory to this in some way? I have a great slide of Bill Patry saying something snarky about professors in public choice theory, and I'm sorry, next year. So let's talk about broad complete IP policy responses. And you know, they're the usual ones, which I think many of you are familiar with and we can talk about. The first one up is motion pictures in a way. Long, long ago, an express choice was made to protect motion pictures under copyright. Copyright gurus in the room will remember the early case law in which moving picture producers would actually register multiple frames from their movies so that they would send in frame after frame after frame and register them as still photographs so that any reproduction of the film would in fact reproduce their registered photographs. So there was a moment there where there was doubts, and then there was a very quick conclusion to bring motion pictures within the full ambit of copyright. Then, of course, more recent and more kind of an express public policy battle was the battle in the 1970s and 80s on whether to protect software under copyright, under patent law, under a sui generis law, which many people proposed, or under a combination of copyright and patent law, or copyright and sui generis law. And of course, what I find interesting about this is that you can't really say how the alternative reality would have worked out. You can say this reality worked out okay. And I was at a copyright roundtable where one of our colleagues that those who teach know well in IP, Pam Samuelson, was there. And I don't think Pam has said this in public, but she said it at a copyright roundtable, so it was public in that sense. Of course, no one was there, so it wasn't public in that sense, just professors. But she was mulling and she said, you know, and Pam Samuelson does not shirk from criticizing anything she does not like, whether it is a law or your tie. And so Pam says, you know, I was really an opponent of this, and I thought a sui generis system was better, but I'm really not, it hasn't turned out that badly. Now that is great praise from Pam Samuelson. You know, it hasn't turned out that badly. And so we can't say that the alternative reality of how we might have done this big grand decision otherwise would have been any better. Another decision I find really interesting is sound recordings, because we as the United States made the choice that we would layer copyright such that a sound recording would have a copyright in the underlying musical composition, and then it would have a copyright in the sound recording. And as many of you know in the room, most jurisdictions don't do it that way. They instead create a neighboring rights system. And as I've been thinking about this, as you think about the tremendous differences between the copyright in the musical composition and the copyright in the sound recording, and how vastly different institutions have evolved and we are still working on to this day in the Music Modernization Act, we may have in fact actually created a sui generis right, but not had the political fortitude to say it was anything but copyright. And so we may have actually really created a neighboring rights system and not admitted it. And then, of course, I can't help but talk about one which isn't about protect or not protect or how do we protect, but the Bayh-Dole system. And outside copyright, I'm fascinated by the Bayh-Dole system. The Bayh-Dole system was a very clear, epically large choice to take the $100 billion that the United States government spends on research and development each year, and which by 1980 had produced 28,000 patents which were said to be on the shelf collecting dust. It was pre-digital, so they probably were on the shelf collecting dust, and that they weren't being licensed. Now, truth, you don't want many of them licensed, like the fin technology for the cruise missile and the explosive detonator technology. But it was true. There was a vast, vast range of patents which weren't being licensed. Bayh-Dole changed all that. Again, academics can criticize it, but there's no question that it has had a tremendous economic boost for the economy. I've seen different estimates. The one conservative one I will take is that Bayh-Dole, since enacted over the decades, has produced 250,000 jobs, regular jobs, and has contributed an annual $180 billion to the U.S. gross domestic product. So those are examples where it's hard to say we got it really wrong, right? Big policy choices where we got it wrong. But let's be neutral. Let's accept that we don't know what the alternative reality would have looked like, and we can't say for sure what it would have looked like. All right, let me talk a little bit about policy tweaks to respond to technological developments. And here I'm going to go back to something that Bruce already talked about, and that is the interesting use of commercial. Commercial does pop up at several places in the copyright statute, and Bruce is completely correct that it is used or has been used as a marker between that which we want to regulate and that which we don't. And of course, that was built into the law in 1976 because this is how the world looked. The world looked, if you drew your little, I'm very fond of these because I can understand them, but they look scientific. And that is, if you drew the world between commercial on the one hand and private nonprofit and large scale and small scale, in 1970 and 1960, when all this was being negotiated, the large scale stuff in the pre-networked environment was commercial. And the private nonprofit stuff was always small scale. It didn't matter. And the private nonprofit large scale stuff didn't happen. And so it was an easy world in which you could say commercial or non-commercial will be our draw line. And of course, that world was changed by peer-to-peer systems, where suddenly the problem for us conceptually was the technology and its diffusion put a huge bunch of activity into this block, and we didn't know what to do. But to fill out Bruce's story, what did we do? Our courts reinterpreted the word commercial. So in the leading case, in the Napster case, and this didn't require a legislative change, our judges, to their credit, saw that they could reinterpret the word commercial. And so the trial court says, a host user cannot be said to engage in a personal use when distributing the file to an anonymous requester. And basically, in the definition of commercial, Napster users get for free something they would ordinarily have to buy. And the Ninth Circuit said, that's right. And they give us a very almost formalistic new definition of commercial. Direct commercial benefit is not required to demonstrate a commercial use. Rather, repeated and exploitative copying of a copyrighted work, even if the copies are not offered for sale, may constitute a commercial use. They redefined the word, right? Didn't need to go to Congress. We'll redefine it for you. Thank you very much. All right. But what I find also interesting, because I do international work, is this had been actually foreseen by the government people who were negotiating the TRIPS agreement. So the TRIPS agreement, remember, is essentially written in the late 1980s. It's finalized in the mid-1990s, 5 years before we see Napster. And yet, the US negotiators, because I believe they are the ones who put it on the table, this particular article, Article 61, didn't say commercial piracy or didn't say unauthorized reproduction and distribution, commercial reproduction distribution. They said piracy on a commercial scale. And so they had already moved ahead. Now, I'm trying to figure out why, looking back as a historian, and the best thing I can say is that by then at least, we had seen the photocopier cases. And we had seen course pack cases where people were arguing that substantial reproduction with photocopiers wasn't commercial. And so the negotiators were trying to get ahead of that curve a little bit and changing the concept of commercial into commercial scale. All right. Let's go on to that third category, misunderstandings. And here I will ask Troy a question. Maybe you will have some better recollection than I. And that is that lots of people in this room know by heart the safe harbors of Section 512 of the Copyright Act. Many of you, I would say, could probably recite them in your sleep. It might be a nightmare, but you could be reciting them in your sleep. And we all know the Sturm und Drang over the known or should have known standard, the actual knowledge standard that or is aware of facts or circumstances from which infringing activity is apparent. But what I found striking in the past few years is that there was never any knowledge standard put into 512A. And 512A doesn't have a knowledge standard because 512A concerns the transmission lines, or what we sometimes call the tubes by which the data was flowing. And I can tell you that in the Clinton administration at least, I believe, as I recollect, there was an ill-informed layperson's assumption that the transmission lines or the tubes would just never know what was going through their system, so there was no need to have a knowledge standard. There was no point to have a knowledge standard. And Troy, I don't know whether you can tell me if you and Ed Damage were much smarter than us and actually thought about it and talked about it, or whether that was just kind of something that passed over for you too. And why I find this interesting is this is a misstep. It's a misstep, a big one, because it only took a couple years before it became evident that the 512A entities did know, through packet sniffing and watching network patterns, particularly after BitTorrent emerges after 2001, they had a very good idea of what was happening in real time on their networks. And they knew pretty well when a particular user had a very, very, very likely probability that at that moment they were downloading a film through BitTorrent without authorization. And so to me, this is a lesson about how not foreseeing that possibility really curtailed ever being able to get the legislation amended to fix that. Because back in 1997, back in 1998, people working on this could have said to AT&T, hey, how about a knowledge standard there? And if AT&T had said, sure, we'll never know what's passing through the transmission lines, fine. And if they said, no, that's a really bad idea, then we would have known they knew something we didn't know. So that's an example. All right, last, I only have 30 seconds, but can I take 2 minutes? I'm going to talk about...
The authority is right down here.
Okay. I'm going to talk about technological developments we ignore, and we ignore them as long as we possibly can. And I can only give you 2 examples in this time. I'll give you a little one and then a big one. So on this last point, technological developments that we ignore, yesterday, Jessica from RIA told you that the Music Modernization Act was the first new copyright legislation in ages. She was wrong. Because on Tuesday, President Trump signed into law the Marrakesh Treaty Implementation Act, which I spent a lot of time working on, and that revises the exception in copyright law for persons with print disabilities, for the blind. And so it revises Section 121 of the Copyright Act, and it creates a new section, Section 121A. So here is the old definition of a specialized format. That is, the exception is designed to take a literary work and to say you can make a specialized format without the copyright owner's permission. And a specialized format was defined as a Braille, audio, or digital text which is exclusively for use by blind or other persons with disabilities. Okay? Now look at the new definition. An accessible format means an alternative manner or form which gives an eligible person access to a work when the copy is or a phonogram in the accessible format is used exclusively by the eligible person. Do you see much difference? Hopefully not. You're not intended to see it. But the change is the realization that ebooks and the emergence of digital files are merging the formats that sighted people and people with print disabilities use. And eventually, all our ebooks and all our ebook browsers will be able to serve persons with print disabilities. So it can't be defined by technology anymore. It has to be defined by the target of the audience. And we will see if that holds up. But let me give you a more interesting one because this is the end of the day and I will entertain you a little bit. So I want to talk about photographs. Do you teach copyright? Do you know this case? Ryan had a picture of this. This is already on the screen. This is Oscar Wilde number 18, 1884 case in which the United States Supreme Court said, yes, photographs can be protected by copyright if they have the originality, creativity, if they cross the minimum threshold of original expression. And certainly we have a lot of modern photography which meets that standard. And so there we go. That should liven up your day. This, after seeing dead white men all day, here is one of the last great photographs of Marilyn Monroe. And this is Bert Stern's classic photo of her in her last photo shoot. And if that doesn't excite you enough, here's John Malkovich's parody of it in 2014. These are definitely creative works, right? But the problem is that what we don't want to talk about is that a lot of modern photography may have no originality at all. I can make the case to you that although the dispute publicly was fought about fair use, that Mandy Garcia's photo of then Senator Obama actually had little or no originality in it. because he made almost no choices in how he took that photo. And if you even think he chose when to take that photo, you should know that at that event he took over 1,000 photos because he has a machine gun camera, and he didn't even recognize that one of his photographs had been appropriated by Shepard Fairey. But more importantly is here is Google Maps with Google claiming copyright, and Google Street Views with Google claiming copyright, and Google Maps and Google Street Views all claiming copyright for billions and billions of images which have no originality. And we don't talk about it. This is a technological change, the explosion, the fact that we as people have taken more photographs in the past 18 months than all of humanity before that 18 months, and most of those photographs are not original, we don't want to talk about yet. So, all right, that's all I had to say. I actually find this very, very interesting stuff. It is the poor sort of memory that only works backwards. Thanks very much.
Thank you, Justin. And the star you've all been waiting for, Ron Katznelson.
Thank you very much. Also, thanks for the CPIP group for inviting me to talk about this. And I want to mention the fact that CPIP is unique in the sense that they combine both people from academia and industry. I was asked to come from the perspective of somebody who's been in industry. I'm an inventor, 25 patents, but also after working a lot in that industry, I became interested in some of the arguments made by academics about the patent system. So this presentation is a result of some questions that arose after I've done some work on this history of certain aspects of the patent system, and so that is my focus, whether government sources on which academics rely are essentially reliable on the issue of whether patents, pioneer patents, have caused a delay or did they block downstream development. Also, I've got to make sure that I make a disclaimer. These are my personal views, even though I'm part of the IEEE Intellectual Property Committee. I say this here. Everything I say is my own personal views. I just want to be cautious about that. So allegations have been around about pioneer patents that retard development. So a sample example that a lot of people in law schools know is the one by Merges and Nelson, basically presenting a whole bunch of what they considered as evidence, empirical evidence, that granting patents for pioneer broad patents is stifling the advance in technology. And for each of those cases, they gave some facts or alleged facts. And a colleague of mine, John Howells from Aarhus University in Denmark, and myself, we started looking at each of those cases. And to some degree, we found that, as Professor Joe Gabriel said, cited Hayden's White meta-history, that historians don't really tell you what happened. They tell you a story. And so I think you'll hear the stories here, but not really what happened. So there was an adverse narrative about pioneer patents. And particularly pioneer patents are those in which the claims are often fairly broad because it's a new technology, and it also ends up being litigated more likely and so on. So for example, on the Edison incandescent light example, it was alleged that the lengthy and expensive patent struggle in the lamp industry from 1885 to 1894, when the patent term of Edison's patent expired, was a serious damper on the progress in the lamp design. And this was a textbook on the industry back in 1949 by Arthur Bright. In the Wright brothers airplane situation, there's an allegation that before the war, 1917, the development of the aircraft industry was seriously retarded by the existence of these disputes, And again, the Wright brother patent, or the owner of the patent, was essentially accused of being a troll. And the Selden automobile patent was also had been attributed as a slowdown for Henry Ford. And the Fleming diode patent has been said to have caused a market or a patent thicket, so to speak, in that the diode patents and the triode technology that DeForest came out with basically precluded both from making radio tubes, okay? These allegations are really there, and you want to say, okay, what's the evidence for those allegations, and what's the source of these allegations? 2 years ago, I described all of these four cases in this work, and I went over some of the results. The specific allegations proven wrong in all four of these cases. There's no evidence to support these allegations of development block. We found that copious evidence of development actually does exist, and that is the exponential increase in patenting rate in the relevant technologies. So people who were blocked, they still are patenting, they develop things, so they must not have been blocked. There are steeply rising rates of investment in the related technologies. Production, which shows that the people are making these products anyway, and also new industry entrants, people who go to make new products based on these technologies, and none of those were stifled. And further, that licensing did take place, despite some of the allegations that they did not. Now, so this kind of summarizes the four areas. In the case of the early aviation patents, our papers on the vacuum tubes, our paper on the Edison incandescent lamp, and the Selden paper. So there are four separate studies, and we actually have a lot of information there showing that none of these things happened. There was no blocking. Then we asked ourselves, and this is the subject of this talk, why are these allegations of development blocks so widespread in the scholarly literature? We observed that these allegations were basically made related to pioneer patents that are old, century old, okay? And you would think that if there are fundamental phenomena of pioneer patent that stifle innovation, you would see it also in contemporary patents that are pioneer. We have pioneer patents today, and yet some of the works that are more recent by the academic community that's addressing that didn't really bring examples from our contemporary times. So why is it that the old ones are really the ones for which empirical evidence was drawn? What are the sources that distinguish those between the old, century-old pioneer patents and today's pioneer patents? Well, it turned out it's the sources. The significant reliance on government sources is what we saw, meaning citation to government sources and elements related to antitrust investigation, legal or lawsuits brought by the U.S. government. And basically, the alleged pioneer patents blocks were part of those government investigation in the heyday of the newly enacted 1914 acts of the Federal Trade Commission and the Clayton Act, both around 1914, and then a whole bunch of investigations started to take place. And you see a lot of these reports in the early 20th century. Let's see. And those reports are the sources that gave undue credence by the investigators. So we looked at those. We looked at some of them. And one of the things we see in this chart, you can see that we are dealing with, for example, the Edison patent. The event of assertion, was around 1886, roughly. The government report, the government source column, talks about the various sources that reported about what happened to Edison. But that activity really dealt with activity of the descendant company, General Electric, for example. In the years 1907 or later, 1907, 1909 is the GE case, the antitrust case against GE by the U.S. Again, another one in 1949, the period of 1927 to 1941, the investigation by the Congress and pooling of patents about the undue power of patent pools related to some of the activities of GE, again, 1903 to 1933. None of them dealt with the actual issue of what happened in 1886. Yet, they do mention descriptions of what happened to the Pioneer. GE, the parent, the descendant of the Edison Company, was said to have exploited its monopoly power and so on in the case of these lamps back to Edison's day. So it's like a description of this, even though it wasn't part of the investigation or part of the government report. But scholars did refer to those descriptions. So the same thing, for example, has happened in cases related to the Selden patents. You have the FTC report of 1939, look at General Motors activity. You have the TNEC, the Technical National Economic Committee, looking at market power in 1938, 1940, in terms of what would happen. But they looked at activities that are much later. Even though the Selden patent was asserted in 1903 through 1914, the antitrust investigations were for a descendant company or a descendant element in the industry much later. And in the case of the Wright patent, here's another example where various sources were cited. And you can see on the right side, the academic papers, the scholarly papers citing those cases are numbered here because they're the number of our list of these references. These are contemporary references. They all really cite the description in this last column, the description of the pioneer patent holder conduct. That's what they cite. So note, it was not a central issue in the investigation that was alleged. It was basically a statement, and there's no fact-finding as to those things. So it's just reciting perhaps what the government has alleged is essentially a litigant. So those were cited because they're government reports, and you can see the nature of those reports. The same thing about the Fleming diode, and the same thing, FTC has written a report back in 1924 alleging RCA. Essentially, the RCA was the assignor of the Fleming patent later on. And again, it was all about its tie-in activity in 1919 to 1920s, 23. That was the investigation. Yet they went back and just described for background how the original patent, the pioneer patent, stifled innovation. Now, why is that? There are problems with that because the antitrust investigations of competition have a different standard. Okay? They're not the same as proof that something actually happened. The reports and the court findings recite allegations of the government as a litigant or interested party in the issue. It's one side, okay? Not the result of an adjudication. Was there really patent blocking at the time? That was not even a question before the entity, the adjudicating entity, but it was an alleged element. Finding liability under the FTC Act does not require showing actual harm. Whether there's blocking or not doesn't matter, okay? If you have a method of competition that may cause a blocking, incipiency of an action is good enough for Section 5 of the FTC Act. So they were meeting their threshold by alleging something could happen, didn't really happen. And the records don't show an attempt by the defendant, by the patent holder, to essentially refute those things, because that was not the issue at hand. The issue at hand was the activity in the early 20th century of market collusion or misuse of patents in other areas, not the behavior of the pioneer patent holder at the time. And there was no interest at the time for those people to refute that. A lot of them had to deal with consent decrees, and settlement, and you don't challenge the government, you basically do a deal. So you won't see a challenge, a full litigation of that question that was really not the matter at hand. So what we are trying to see here is a source of information that has inherent non-reliability to it. It's not a finding of fact. It's an allegation by an interested party. And the motivation to have done that is to show prior conduct. I'm here talking about conduct in 1903 to 1920 or whatever, but I'm going to tell you what this patent holder's parent or earlier version of that holder did, and you should consider that as potentially a prior conduct, and it helps make the more harmonious story that they were trying to carry on later on. So knowing all of that, you basically see that these actions, even though they dealt with meritorious cases, they had a real case, antitrust case for these things. But it wasn't the pioneer patent enforcement. It was the misuse of patent or tie-in of patent in some other market restraining activity that allegedly and potentially correctly should have been restrained, should have been arrested. And that's the point that is made. People forget that while achieving correct resolution of an antitrust problem, some ancillary data was put in, and now it's available for scholars to cite. Conclusion. Scholars should not accept without close scrutiny government sources, allegations on the effect of patent enforcement. You have to be very careful. What is the reason for those sources? What kind of study did it make? And this is true today. For example, in 2013, the White House issued a report on the Troll report. And the FTC later issued a report on the PAE, okay? What type of study was it? Everybody criticized it. There was a sample of 40 patent holders. Is that what the industry does? Is that what the patent assertion industry does? It's a different goal. It was an interested party or an interest to show, but not a true analysis of the enforcement of patents. Government sources are typically prosecutorial in nature. They're investigating. They have a position. And they're untasked with the actual question at hand that was later cited, and that is how enforcement of pioneer patents took place. So with that message coming from the industry, knowing that these stories just don't jive with my experience. People design around patents, they do analysis, they move forward and take licenses. When there is very high collective benefit that can come out, the collective surplus, people negotiate and arrive at some decision, and there's not a stifling of further development. So this discussion was something that John Howells and myself worked together. So this is going to be a paper, both of us are authors. He's going to be the second author. And the references I refer to here are some of the cases that are referred to in the slide pack are listed here. So that's pretty much it, and I will take any questions as part of the panel.
Thank you very much, Ron. All right, questioners, you don't have much time, so let's get to it. Do we have a microphone?
For Professor Gabriel, the Supreme Court tells us on patent eligibility that inventions, that laws of nature are an exception, and they put this notion of the tools of scientific research, so on and so forth. And there's a lot of coupling of that, particularly in the medical field, Mayo, Myriad. In your research, did you find that type of analysis as a justification historically that the medical profession should not be patenting things because they were part of the laws of nature? Did that type of analysis ever show up, or was it more on the ethical aspects you mentioned?
Yeah, sorry. So technical conversations or technical disputes within patent law did play out in kind of the reasoning processes of physicians and life scientists, but it did refracted through the expertise of patent lawyers, right? So they don't, so within the scientific communities, the scientists and the physicians typically didn't understand patent law very well. They had kind of vague senses of it, right? And the patent lawyers translated for them, right? And then they kind of proceeded on, right? But so I would say that kind of the ethical considerations for the people I'm talking about, for the scientists and the physicians, kind of were predominant over the technical legal questions.
Yeah, I'm taking this out. My point is actually to take this outside of the patent law.
Okay.
That this is an exogenous question, right? Whether something is a law of nature or not is an exogenous question to the patent law. That's the mistake the Supreme Court makes, in
Yeah.
fact. And so if this was really a concern, if this was really the issue, then I would expect to see it historically raised by the relevant scientific community to say, we shouldn't be patenting this stuff because of these larger questions. And
yeah.
that's an exogenous
Yeah,
to the law
gotcha.
itself.
Yeah,
That's what
gotcha.
I'm asking.
Yeah. No, yes, they did that. So they would, so when the ether patent happened, right, in 1848, there was a lot of concern among the medical community about the ether patent because they considered ether kind of a naturally occurring thing, right? It was a chemical process, right? You took a chemical reaction and then had a gas, right? But it was but it was kind of a natural thing. You see that like in the famous quote by John Salk about the polio vaccine, right? Can you patent the sun, right? That's actually not completely fair quote because they actually did try to patent the polio vaccine, but they weren't able to, right? But it points, I think, to a general kind of sense that naturally occurring things should not be patented. Of more concern was the idea that once you patent something, that it prohibits other kinds of uses, right? So there's a lot of concern about, like, if you patent, like the Vaseline patent in the 1870s, Cheeseboro Manufacturing Company patented Vaseline, and it was kind of the first therapeutic salve for that use, right? They use it for burns and stuff. And there was a huge amount of concern about the fact that the patent would prevent other similar products from entering the marketplace.
That would
among
be preemption
physicians.
for you, the preemption part of 101.
But that's among physicians, and it's not related to technical aspects of patent law. Yeah.
Ron, I had a comment to share with everybody. I think it's a feature that those papers that you've written on Selden, diode, triode, the Wright brothers, et cetera, are generations-old technologies. I think it's intentional that technologies that only could be, data that could only be found in the bowels of the Smithsonian were used to set a framework for denigrating the patent system. And I want to commend you for going to the Smithsonian and digging in the bowels. So thank you.
Well, my only comment is that I would not ascribe it, if I can find a more rational or reasonable explanation, which is the sources. And I think academia, look at the sources. And those sources happen to have been from the antitrust reports and the heyday of the antitrust enforcement. And I would not ascribe to the academics a role that goes beyond just looking at sources. I'm just saying be cautious with those sources. And yes, other people can exploit the academic work later on, but these are not the authors.
Yeah, this is for Professor Gabriel. I have a lot of stories that I could tell you. I worked with a guy who had worked with Paul Ehrlich. He was like 92 years old. This was back in the 80s.
Yeah.
And he was a young medical student. And there was a tradition of these medical students acting very strange and altruistic ways. They would self-dose themselves.
Sure.
And when you broke out of that altruistic mode, you didn't have the people to test your drugs on. You lost your patronage from your university. You really had a lot of problems. And I think the reason why you see the patents really ramping up, in 1917, 1920, the whole system broke down, especially in Europe, because of World War I. I mean, people like Ehrlich, who won his Nobel Prize in, I think it was 1907, he lost his patronage.
Sure.
It just totally disappeared. But that altruistic approach served everybody very, very well. Again, I remember stories about Halstead dosing his students and dosing himself. Remember, he used to give himself cocaine
Yeah.
to experiment.
Yeah, I don't disagree, at all. I think the altruistic aspect of medical science is at the heart of, changes in the biomedical, in changes in biomedicine over the course of the 20th century. I don't think that, I think that's a very important part of the story, and I don't think it goes away at all, right? But it's also a story that is told constantly, right? It's told to scientists by scientists, and it's told to medical students by doctors. And there's other aspects to it, right, that are also true, right? So it's also true that clinical experimentation gets linked to the development of very powerful substances during this period. It gets linked to clinical trials among vulnerable populations during this period, right? So there's other kinds of concerns, even as the humanistic and the kind of the noble side of medicine is also very true. And then part of the story is also about the seizure of the German patents by the FTC and the distribution of those patents within the biomedical community and so on.
But it was also a time of medicine shows, and people were very suspicious of the whole process. There was a lot of quackery
Sure,
floating
yeah.
around, and the best way to avoid that quackery is to stick to somebody who worked for a university or an institute. That
Yeah.
was proof positive that you had something that was real.
Yeah, absolutely, absolutely.
Thank you. Adam?
Well, I defer to the moderator if you have questions, because
No, you raised your hand. You've earned your you've earned your moment in the sun.
This question for Professor Gabriel as well. And I apologize if you addressed this in your book and I haven't read your book yet. It's on my to-read list under a huge stack of books. But to what extent also can you attribute as a factor in the shifting of an interest in patenting medicine the fact that at the very end of the 19th century, you actually settle on chemistry as a science, and in fact the foundation of chemistry, right? Because before, which is of course the periodic table of elements, because throughout the 19th century there was a massive dispute about what was the nature of elements, the atomic theory of nature was in fact very much up it was a topic of debate among natural philosophers at that time, and this is why medicine was. And patent medicine was viewed as quackery because people were still developing the germ theory of disease. They didn't know what caused things. And once you have settling of the basic foundational science for medicine, right, which is the periodic table of elements, understanding the atomic nature of molecules and atoms and things of that sort, then you then have a resulting explosion in productive inquiry into therapeutic treatments and drugs. And so a shifting away from patent medicine being the snake oil salesman techniques, and actually an understanding that no, these are adrenaline and eventually sulfates, right? These are actually legitimate treatments that can treat people, as we've shown through the evidence, because we now know the underlying facts of chemistry.
Yeah. So I think that there's a lot. I think there's a lot of truth to what you're saying. I think it overplays the importance of chemistry in drug development in the 19th century. And I personally, I think that the origins of the turn toward patenting in the kind of late 19th century are more about the development of clinical trials as a means of justifying the commercial introduction of new products, right? And then once you start commercially introducing new products, the need for monopolization or in order to protect the investment process. So I could be convinced about this, about the chemistry angle to it, but I didn't see that in my own work.
Yeah, I was just proposing as another factor. I don't think you can reduce it to one thing, but I think it maybe plays a small role, if not.
Yeah, well, if it does, it would come through the German industry, right? And the influence of the German industry on synthetic chemistry.
Yeah. And then also, Ron, I would commend to you an article by your co-panelist, Justin Hughes, on intellectual property and the historiography of intellectual property. Justin, you can correct me on the title, from 2007, where he has a section in there called The Hall of Mirrors, which in scholarship, which is very significant, where he shows that an initial error citation gets recited and recited, and then it creates a sense among this is how conventional wisdom is created among academics that is clearly
nested
proven.
citation paradigm,
Yeah, and it's beautifully demonstrated in a whole area in the IP context, and so I recommend taking a look at that.
Which is itself a great example of the power of technology. Once a citation is on Westlaw and Lexis, it is truth. So. Other questions? Why don't we move to the other side of the room? Is that okay, Kevin?
Yeah, good discussion here, and the specific discussion about medical technology and science early on, that patenting was not considered noble and not pursued. Also in computer science areas, I can remember in the 1970s, computer programs from the old school computer programmer's viewpoint, again, it was something not considered noble that you pursue protection of computer programs, that the knowledge in computer programs or how to program should be disseminated to everyone, meaning it should be given out to everyone. Similarly, in a medicine. In a sense, the question I want to ask is that technology, which I'm defining as the application of physical sciences, meaning you apply physical sciences to solve a human need. That's the application of physical sciences and should be the definition of technology. There hasn't been a good measurement system for it. And scientists have a saying that says, if you can't measure something, it doesn't exist. That may have been perhaps what in the past we've dealt with and we still deal with, in that we don't have a system to measure technology in a scientific sense. Any observations or solutions to that case?
We will start with Ron.
Well, there are quite a few measurements people use to ostensibly describe technological development or activity, and we've used it to see just the patenting rate, the number of patent applications are issued in a given time. We see a very interesting development of patenting rate. In the case of Edison, we saw all of a sudden a lot of patenting just around the time he asserted his patent. It turns out we looked at them, they're all design around patents, they're invention around. And you could really quantify the intensity of patenting in that area. Then you could also measure the significant technological advance, perhaps, in these patents by citation analysis. It's a measure. Forward citation or backward citation. So there are some numerical and some tools to measure proxies of technology. And patents are probably a good element because we have patentability requirements. Something has to be non-obvious, has to be novel, and that's a yardstick for technological development. Then there's R&D in technology, but that's not always going to lead to results. But I suspect that there are a significant number of indicators for technological change.
But you're only talking about indicators for all fields, whereas if you started
Hey, Justin.
field by field.
Speak into the microphone.
Just, I was saying, if you go field by field, you might be you would come up with different indicators. So you're looking
Yes.
for indicators across everything, whereas if we start.
No, you could do patents in a particular area.
No, but not even patents. If you start using economic data
Okay,
or,
yeah.
so
Other,
you can
right.
start using non-patent, non-IP data, sector by sector, to try to measure technological progress.
Well, technology investment, I'm not sure it's going to be progress.
Diffusion.
Yeah. Well, if you have an R&D spending, I don't know what the impact is, but I think it's the input. That would be the input. The output is some of the things that you would see in terms of technological development.
Last question. One more.
Hey, glad to have the last question. So I've heard a couple of mentions of antitrust. I've heard from Bruce about FASCAP stuff and Ron talking about all of these things. And it seems to me a lot of IP history, including stuff I've written, has sort of tunnel vision on IP. But so much of it really does seem to have an interplay of IP and antitrust, and the doctrine's really developing at the same time. And I wonder if you have any thoughts about that.
Bruce, you want to take a swing at that?
Yeah, I mean, I mean, my specific focus on that issue was just in how, at the time of the the music public performances licenses were getting off the ground, there was just a cluster of concerns, and I think it's been described well as sometimes people enter into copyright debates in particular, which is what I'm familiar with. And are stating various concerns, and they find various legal boxes to put it in. But their concerns might be, beyond what legal boxes they're talking about. So, it's a violation of copyright, as understood, or it's a violation of antitrust when, in fact, it has to do with, we've never been subject to this before, and we don't think we should have to be. So I don't, the antitrust is a bit out of my toolkit. So I don't have any specific concerns about how antitrust law has been used over the 20th century. But I think that's how it was coming up in that debate.
Justin, would you like the last word?
My only thought on that was, looking outside the United States, you find a few jurisdictions, not many, but a few jurisdictions that literally put the IP and antitrust authority together. There are a few. I think there are three, and the only one that comes to mind for sure is in Peru. The agency that is in charge of IP is also in charge of antitrust. I think it's called Indecopi.
And on that note, Bruce, Joe, Justin, Ron, thank you very much.